Now, this one seems bizarre. The judge in the mega pop star Britney Spears custody battle ordered her not to drink alcohol or take non-prescription drugs within 12 hours of seeing her children. But what about the rest of the time? Family law attorney Don Schweitzer joins us in Los Angeles. Don, I've been stuck on this for 2 nights, having looked at this order where it says you can't use non-prescription drugs, which I presume may not over-the-counter drugs, but cocaine or something else, 12 hours before. Is this an unusual order? Because the rest of us think you're never supposed to use it. Why does a judge have to put that in the order and sort of give her a pass? It's okay to do it outside that window.
Granted, it's not unusual when you take into consideration California law regarding the court's limited ability to order drug testing and use positive tests in custody evaluations. The court in California cannot use a positive test of drug use in and of itself to make a custody determination. But what a court can do is say that if you use drugs at or near the time that you're in care of your children, that's a significant factor of taking visitation away from you. So the court was very careful in the way that it worded this order so that Britney Spears knew for a fact that if she took those drugs at the time that she had custody of the kids, that she would be in trouble.
So I take it the judge would say then you can't use drugs, illegal drugs or non-prescription drugs other times, but that it was fashioned this way for that specific purpose alone.
Yes, and I think it would be fair to say that in California, a family court really has limited jurisdiction in telling people what drugs they could use and what they could do in their own time. A case called Wainwright, which was by the California Supreme Court, made it real clear that family courts have limited jurisdiction, unlike criminal courts. So they don't have the ability to telling people, hey, you can't do things at your own time, but when you're with children, then that's a different story.
All right, Don, it seems that this decision by this judge was made on the basis of 3 hearings on September 17th, October 3rd, and October 5th. Do you know if he heard from any witnesses, or is he simply hear from either of the parties that may have shown up? I know she didn't show up, but what's the basis for this opinion?
I can't imagine this court making such a drastic change in custody without it hearing from some witnesses and having some really hard evidence.
But you don't know it. But I mean, you can't help us out. You can't help us out.
No. I can tell you this, though, is looking at the minute order and reading Commissioner Gordon's statements that he had to have learned of something that was drastic in order to make the change.
Or otherwise he's out of his mind. But we're assuming he's not out of his mind, right? Okay.
Right, and he's protecting the privacy of these parties, and so it's a little hard for us in the public to really determine what's happening there because he's respecting their privacy in a lot of ways. In the order, he talks about my prior orders. He doesn't specify what those orders were.
All right. Now, Gloria Allred, who's very familiar to our television audience, maybe you even know Gloria out there.
Yes.
Everybody knows Gloria, I guess. She represents a client who was a bodyguard who worked, he's a former bodyguard, worked for Britney from March until May 17th. And he's not seen her since, has no information since May 17th. Would it be inappropriate or appropriate in making a custody order now for this judge to consider his declaration when it is stale in time or ancient?
Greta, I think that you know that a court has to weigh all the evidence, and it just depends on how much weight he's going to put on this gentleman's declaration. I would argue that, it is remote, and the court shouldn't consider it greatly, but it has to consider the evidence. This court has to consider all the evidence presented and make some determination, so it's not irrelevant.
I would think it's almost silly because he didn't even come into court. Now, no one asked him to come into court, but he basically signed a piece of paper, Gloria filed it, and it's ancient and distant. Okay.
Let me explain that to you. In California, we have what's called riflerized decisions, or riflerized declarations. The court can make rulings just based on declarations during these pendente lite hearings. Other than a trial.
Even something that is 4 months old that hasn't been cross-examined, that would be okay in your mind to be something you would make
not in my mind. Not in my mind. I've got some problems with the system, but I'm telling you that's how it works in California.
All right, well, go ahead.
In California, our family courts are so congested that the Supreme Court has allowed trial courts to make significant rulings based on declarations. A lot of us think that that's wrong, and particularly in something like this when there's a change of custody that's so dramatic.
And I agree with you. So court congestion allows for something the rest of us think is probably not right, just sort of like your jails are overcrowded and your sheriffs make decisions on who can get out when the judges have time. You got an interesting system out there, Don.
Don't blame me for the system, Greta. I just operate in it.
I understand totally. I understand. Thank you, Don. Actually, Don, I want you to stand by. Don't go away because I need you in a minute.